And so I won't be talking about the amendment. I'm arriving at a peculiar moment in the debate, but I want to speak briefly to the main motion, C-12, a bill that's attempting to resolve a difficult issue by proposing a series of measures to speed up processing of asylum seekers entering Canada. This bill worries me and troubles me. As a Canadian citizen, I always believed that as a wealthy country, we have a duty to be generous to those who knock on our door because their safety is threatened in their country of origin, and they have to prove that they are threatened, which is complicated. I've met with asylum seekers in my life, and every time I could read conflicting emotions on their faces, hope mixed with fear, immense fatigue, and comprehension, the desire to save their children, to offer them a better life. I ask you the question, dear colleagues, what would we do in their place? This bill makes refugee claims inadmissible 1 year after the claimant's first entry into the country. This tightening up of the rules has consequences. Gauri Srinivasan of the Canadian Council for Refugees gave an example of a situation created by C-12. A baby visiting Canada with his parents in 2020 would be denied asylum here 20 years later, even if they were persecuted as a human rights activist in their own country, simply because they had previously set foot in Canada. That is absurd. On behalf of the Canadian Bar Association, Diana Okin-Nashoff rightly said persecution does not follow legislative timelines. It is not limited to the year following entry into Canada. Several factors explain why an asylum claim cannot be made in the first year. This includes precarious living conditions of claimants and the obstacles faced by women who are victims of domestic violence. It's true that those deemed inadmissible under the two new provisions of C-12 could still apply for a pre-removal risk assessment known as PRRA. This assessment was originally supposed to take place before the removal of a person who has exhausted all their options in Canada, particularly the hearing before the Immigration and Refugee Board. From now on, the PRRA may replace the Commission, or rather, the Board. We heard from many witnesses who explain that this is not an appropriate substitute for an in-person hearing because the Board, particularly because this bureaucratic process carried out by civil servants rather than independent commissioners, doesn't guarantee the right to be heard and to assert one's credibility in person. This runs counter to a ruling by our Supreme Court, which concluded in the Singh decision that refugees have the right to be heard in determining their fate, as these are cases of such fundamental importance that fairness would inevitably require a fair hearing. This also runs counter to the requirements of the High Commissioner for Refugees, who recommends that a face-to-face hearing be mandatory in cases involving asylum seekers. The legal advisor to the Commissioner explained in a committee that when an asylum seeker has the opportunity to tell their story, they can provide details and context that may dispel any doubts decision-makers may have about certain aspects of that case. Hearings allow a more thorough examination of the evidence, thereby reducing the risk of approving illegitimate claims and accepting only claimants who meet the definition of refugee. Furthermore, although the ineligibility of claims could reduce the number of decisions reviewed by the overburdened board, the outcome of pre-removal risk assessment may be challenged in federal court. While C-12 is presented as reducing delays, it could overload the federal court, which is already reviewing a record number of refugee claims. Another concern regarding fraud. When it comes to fraud, C-12 grants the government extraordinary power to suspend or cancel claims en masse with minimal oversight and on the basis of a vague standard of public interest. There's no appeal, there's no individual assessment, checks or balances, or oversight. The executive director of the Migrants' Rights Network points out that or rather, the government announced in the budget speech that asylum seekers will have to pay $4 per federally covered prescription drug and 30% of eligible services, including dental, vision, and psychological care. Several groups, including pediatricians, believe that these cuts could have a major impact on the families of asylum seekers who often suffer from psychological and financial distress. This reform, therefore, reduces the support available to asylum seekers. It's true that several other countries have much tougher refugee policies than ours, specifically the United States. In the U.S., where there's a maximum one-year deadline for submitting an asylum application and there is also a range of inhumane deportation practices, but that's not an example to follow. Another difficult debate is happening here in the Senate today. We are not the government, obviously, but we do have a role to play to protect minorities, those who are the most dispossessed, and asylum seekers fall into that category. It is up to us to find the balance. It's not easy to find the balance between the willingness to reduce processing times for processing refugees while maintaining procedural fairness and transparency. Thank you.